are there sufficient facts to support the judge's conclusions of law? The same thing. So to me, this is if you want to use the system, you do away with the redundancy, but it still is within the judge's discretion to require findings of fact and conclusions of law. And I think that's something you all as lawyers should agree upon when we get to the, if we're doing a jury of one, we'll agree that there's no need for findings of fact and conclusions of law. And I doubt the judges will fight you on that. That's just my personal belief. One of the things that if you want a jury trial, and this is, I've been practicing 28 years and I found out that our Constitution requires a 12-person jury. You have a grand jury and you have a petite jury. I always thought petite meant 6. It means 12. But you can stipulate to a 6-person jury, and I've tried a couple of them, and it's a very intimate environment. You can agree it's got to be unanimous, or you can agree that it's 5 out of 6, however you want to do it. There's another hand over here. Yes, ma'am.
If you're submitting jury instructions to the judge in the jury of one, I guess my concern is I'm a staff attorney for the Supreme Court, and we see a lot of appeals based on jury instructions. So if somebody wants to appeal one of these based on a jury instruction that the court didn't instruct the jury properly, but the judge is, I guess I'm worried about a standard for that, or is it just going to be an understanding that you don't appeal these things based on jury instructions?
And the way the process is supposed to work, a jury trial, one side, this side proposes, this side proposes, the judge settles the instructions, the judge said, these are the court's instructions. Make your objections. Okay? Under the jury of one, is the parties are required to submit joint instructions as to the applicable law. And if they cannot agree, then within those jury instructions, they essentially will set out their legal argument as to why their instruction is better than this other instruction. So really, the instruction becomes an issue of law. And then it's going to have to, the Supreme Court's going to have to kind of sort of work through this too, because if they get an appeal on a jury of one, okay, and it's based upon the issue of law, the standard of review for issue of law is de novo.
Right.
In the jury trial, the court looks at the instructions as a whole and determine whether they're reflective of an accurate statement of the law. So hang around at the Supreme Court a little longer and kind of help us through all this.
Okay. I was hoping you had the answer, but...
So and I think we're running out of time. Do we do? Okay. Closing remark.
Any other questions? These are great.
Could you address, there's no opt-out, but there's an ability for a defendant to ask the court to allow the expedited matter to get out of this process for good cause?
Absolutely.
Can you discuss what you anticipate that taking shape as?
And it goes either way. I mean, to either party. If something happens during the case and you don't feel like this is how the case should be handled. I mean, it could be the plaintiff. I mean, something can happen and all of a sudden $75,000 limit is unfair. And they say, I want to opt out. And here are the reasons, Judge. There's new circumstances, there's new this or that. You know, then it's up to the judge. It's a good cause standard. We rely on the trial judge to make it. Similarly, you know, if you wanted to file a medical malpractice case and say that you're going to cap your damages at $75,000, the defense can come in and say, no, Judge. This is a complex area. We need 2 experts. We need to take these many more depositions. We'd like to opt out. Okay, you know, we're relying on trial judges to do their job well, which they normally do. The thing is once you opt out completely. Okay, so if you're on the defense and you want to have 3 experts, okay, but there's no $75,000 limit anymore. Okay, so you don't get the benefit without the limitation.
And the whole point is that there's flexibility, and I think, you know, I've been involved in claims cases where, you know, you're looking at what you assume to be was a soft tissue injury, and about 9 months after, you know, your client is still treating. You know, some people believe I don't want to file a lawsuit till my client's done treating, or you know, you get however the process is, and all of a sudden you find out you have a herniated disc and you have a surgery that's going to cost $55,000. I think that's a no-brainer for good cause. And saying, you know, from the defense standpoint, and we got pushback from the defense, and my thing was, folks, you're not going to get stuck for more than $75,000. The judgment may be more than 75 with prejudgment interest, but you're not going to get stuck for 75,000. What's the biggest fear right now? Excess verdicts. $100,000 policy limits. Are the young lawyers getting into that courtroom? No. Who's doing it? The veteran lawyers. Because the insurance companies want the veteran lawyers to make sure they don't get stuck with an excess verdict. You got a $100,000 policy. It's a $50,000 case. Everybody pretty much agrees to that, but you can't get it settled. The veteran lawyer litigators are transitioning out. I do a lot of construction litigation. Same lawyers all the time. Sioux Falls, you see the same plaintiffs lawyers, you see the same defense lawyers. Probably 80% of them have gray hair, male and female. So part of this too is to maybe reduce the risk, and by reducing the risk, you create better lawyers, more experienced lawyers for the next generation of clients who need good litigators. Anything else?
It's more of a point. Looking at this is a great idea. I just don't see in the rural areas where our judges are covered multiple counties, their dockets are already full with criminal jury trials, abuse and neglect jury trials, you know, family law trials, court trials. They don't have the time. Is there any emphasis to try and have the bar work with UJS to get more judges back out in our rural areas?
You know, that's a good point. I think I've learned in this profession that if you want something done in the judiciary, try to start at the top. And that's the Chief Justice. And we all know that the Chief Justice is the champion addressing the lack of rural attorneys in South Dakota. The Chief Justice is also aware of the fact that you have 64 courthouses out there, which are underutilized. So this will continue to be discussed, and the mechanism of the ECA, and you would hope, will allow people to take advantage of what's available to them. And maybe we'll see. I don't know if it's in the next 5 years, but you know, work with the judges, and the judges aren't all mean. Some of them have a great sense of humor, like that's Dave. Just a quick story. When he went on the bench, I'm thinking I'll never be able to have anything in front of him. So when a case came in, I was asked to do a special administration to get somebody appointed to accept service of process on a foreclosure on a mortgage-insured house. Talked to the heirs. The gentleman was deceased. Talked to the heirs. Yeah, don't worry about it. We're not going to show up. So I said, Judge Dave, can I do this? He said, sure. So I did all the paperwork and everything, and I found somebody to be special administrator. We get into the courtroom. He's the judge, very formal. Your Honor, went through the stuff, and so he's signing the paperwork, and he gets to the point, and he said, Mr. Morris, he said, you don't have an oath as special administrator. And I kind of looked at him and I said, I didn't know there was such a thing. And he signs, he says, yeah, there is. He said, I'll sign these, but we're not going to file them until you get that oath. So his secretary was still with me, and Judge Staley, in prior practice, did all this state work. So I go to her, I said, you ever heard of oath of special administrator? No. Oath of personal representative? No. So I got a bunch of oaths together and I come up with the oath of special administrator. Had my client sign it, we filed it. About a week later, I'm at a function with Judge Day, and he's sitting there, and he taps me on the arm, and he said, you know that oath of special administration, or administrator? I said, yeah. He said, there's no such thing. I said, there is not. So, but you know, and it's easier as 20 years practicing law that I can approach a judge and say, look, Judge, we'd really like to see this, you know, the presiding judge. Don't be afraid. They're always welcome. They're lonely. They're in their chambers. All they ever get to see is conflict. If that lawyer comes to them, or a couple lawyers come to them, wants to talk to them, and you're asking them to help, especially asking them to help get the process rolling on the ECA, do it.
And here could be I'm sorry to interrupt you, Bob. My one suggestion, the 180-day rule in South Dakota, I mean, that's a statute. I mean, there's a constitutional right to a speedy trial, but it's not necessarily 180 days. We have a statute that says you're supposed to try somebody for a criminal offense within 180 days, unless there's waivers, right? Or good cause shown. Judges respect that. They continuously respect that. Anybody here who wants to get their trial set within a year, I would go in and talk to the judge under that, to treat this in that same way. We've got a year. There's a statutory right to both parties, or a rule, I guess it's a right created by rule, to have their trial in a year. Let's treat this with the same respect as we do criminal cases, and it takes priority.
Especially if it's only a 2-day trial,
Right.
Right.
you know,
So,
especially.
that'd be my pitch. Thank you very much.
Don't we get like the keys to a new car or anything? Oh, a mug, okay. Thank God.
Yeah, thank you, Clint, and thank you, Bob. There is lunch available right now in the hallway, whether you're registered or not. There's plenty of lunch for everybody. Please grab some lunch. We're going to start promptly at 12:40 with our next presentation.